Illinois has a lease termination framework that combines state law with powerful local ordinances, particularly in Chicago, which has one of the most detailed and tenant-protective landlord-tenant ordinances in the entire country. If you manage rental property in Illinois, knowing whether your property falls under Chicago's rules or under state law is the single most important distinction you need to make. Illinois' state-level landlord-tenant provisions are found in the Illinois compiled statutes, primarily in 735 ILCS 5-9, which covers the forcible entry and detainer statute, along with various provisions in 765 ILCS governing landlord-tenant relations. Chicago's Residential Landlord and Tenant Ordinance, known as the RLTO, is found in Chapter 5, Track 12 of the Municipal Code of Chicago and adds extensive requirements that go far beyond state law. Let's start with no-cause termination under state law. For month-to-month tenancies, Illinois requires either party to provide at least 30 days written notice before the end of the rental period. The notice must be delivered at least 30 days before the next rent due date. So, if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice by March 1st. For fixed-term leases, the lease expires at the end of the agreed term. Illinois does not require additional notice for the natural expiration unless the lease specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 30-day notice requirement. For year-to-year tenancies, Illinois requires 60 days notice, a longer period that reflects the more significant nature of annual tenancies. For week-to-week tenancies, 7 days notice is required from either party. Now here's where Chicago changes everything. The Chicago RLTO has specific notice requirements that differ from state law. For month-to-month tenancies in Chicago, the landlord must provide at least 30 days written notice. For tenancies of more than 6 months but less than 1 year, the notice period is 60 days. And for tenancies of 1 year or more, the landlord must provide 60 days notice before the end of the lease term if they don't intend to renew. Chicago has also enacted the Just Cause for Eviction Ordinance, which restricts when landlords can decline to renew a lease or terminate a month-to-month tenancy. Under this ordinance, landlords in Chicago must have a legally recognized reason to terminate. You cannot simply serve a no-cause notice and ask the tenant to leave. The qualifying grounds include non-payment, lease violations, owner move-in, building demolition or substantial rehabilitation, and other specific circumstances. This makes Chicago fundamentally different from the rest of Illinois when it comes to lease termination. Cook County, which includes Chicago's suburbs, has also enacted tenant protections that may affect the termination process. The Cook County Residential Tenant and Landlord Ordinance applies to unincorporated areas and municipalities that have opted in, and it includes specific notice and procedural requirements. Landlords in the Chicago suburbs need to verify whether the Cook County Ordinance applies to their property. Now let's cover termination for cause. For non-payment of rent under state law, Illinois requires the landlord to provide a 5-day notice demanding payment before filing for eviction. Under 735 ILCS 5-9-209, the landlord must serve a written notice giving the tenant 5 days to pay the rent owed. If the tenant pays within 5 days, the notice is satisfied. If the tenant doesn't pay, the landlord can file a forcible entry and detainer action. Illinois' 5-day non-payment notice is a demand for payment, not a notice to pay or quit. The notice demands the rent but does not require the tenant to vacate if they don't pay. Instead, the landlord files for eviction after the 5 days expire if the tenant hasn't paid. This is a technical distinction, but it matters. Using incorrect language in the notice can result in dismissal. In Chicago, the RLTO adds requirements to the non-payment process. The landlord must comply with both the state 5-day notice requirement and any additional notice or disclosure requirements under the RLTO. Chicago also requires landlords to accept partial payment of rent without waiving the right to pursue eviction for the remaining balance, which is different from some jurisdictions where accepting partial payment can undermine the eviction case. For lease violations other than non-payment, Illinois uses a 10-day notice to cure or quit. Under 735 ILCS 59-210, the landlord must provide written notice specifying the violation and giving the tenant 10 days to cure. If the tenant corrects the violation within 10 days, the notice is void. If the tenant doesn't cure, the landlord can file for eviction. Illinois' 10-day cure period applies to violations of lease provisions or violations of applicable building codes, health ordinances, or similar regulations. The notice must clearly identify the specific violation. Vague or generic notices can be challenged in court. For serious violations that cannot be cured, or for violations that constitute a clear and present danger, Illinois allows the landlord to proceed differently. For criminal activity including drug-related offenses, the landlord can file for eviction based on the violation without providing a cure period. Under the Illinois Drug and Narcotic Nuisance Statute, 740 ILCS 40, a property where drug activity occurs can be declared a nuisance, and the landlord can pursue eviction and seek to abate the nuisance simultaneously. In Chicago, the process for lease violations is more detailed. The RLTO requires specific notice formats and prescribes the content that must be included in termination notices. Chicago also has provisions addressing repeated violations and the tenant's right to cure. Landlords in Chicago should use notice forms that comply with the RLTO rather than generic Illinois forms. The eviction process in Illinois goes through the circuit court. The landlord files a forcible entry and detainer complaint after the applicable notice period has expired. The court issues a summons to the tenant, and a hearing is scheduled. The timeline varies significantly by jurisdiction. In Cook County, which handles a massive volume of eviction cases, the process can take longer than in downstate counties. In Cook County, eviction cases are heard in the eviction section of the 1st Municipal District. The court schedules an initial appearance, typically within 2 to 3 weeks of filing, and the case may go through multiple court dates before reaching trial. Contested cases in Cook County can take several months to resolve. Cook County also has a mandatory mediation program for certain eviction cases, which can add time to the process, but may result in negotiated outcomes. Outside of Cook County, the eviction process is generally faster. Downstate courts typically schedule hearings within 1 to 3 weeks of filing, and uncontested cases can move from filing to judgment relatively quickly. If the court rules in the landlord's favor, an order for possession is entered. The tenant then has a specific period to vacate, typically 7 to 14 days in most jurisdictions. If the tenant doesn't leave, the landlord requests a writ of possession, and the sheriff carries out the eviction. Illinois does not have a comprehensive statutory right of redemption for non-payment evictions. Once the 5-day notice expires and the case is filed, the tenant doesn't have an automatic right to pay and stop the eviction, though judges have discretion to allow it in some circumstances. This gives Illinois landlords more predictability in the eviction timeline compared to states with broad redemption rights. On the tenant side, Illinois provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Illinois habitability video, the tenant can pursue remedies under both state law and, in Chicago, the RLTO. Chicago tenants have particularly powerful remedies, including the right to withhold rent, repair and deduct, and terminate the lease when habitability failures are not addressed. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Illinois also has its own Service Members Civil Relief Act that provides additional protections beyond the federal law. Illinois provides early termination rights for victims of domestic violence, sexual violence, and stalking under the Safe Homes Act. 765 ILCS 750. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid order of protection, a police report, or a written statement from a qualified professional, such as a domestic violence counselor, sexual assault counselor, or medical provider. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, cannot withhold the security deposit solely because of the early termination, and cannot report the early termination as negative rental history. The Safe Homes Act is one of the more comprehensive domestic violence termination statutes in the country. It also includes provisions protecting the victim from discrimination in future housing. A landlord cannot refuse to rent to a prospective tenant based on their status as a domestic violence victim or based on a prior Safe Homes Act termination. Illinois also provides early termination for tenants who are victims of human trafficking under separate provisions that parallel the Safe Homes Act protections. Illinois strictly prohibits self-help evictions. Under 765 ILCS 735/1, a landlord who locks out, forcibly removes, or shuts off utilities to a residential tenant without following the legal eviction process can be liable for damages. In Chicago, the RLTO provides even more specific penalties. The tenant can recover 2 months' rent or actual damages, whichever is greater, plus attorney's fees. Chicago courts enforce these penalties aggressively, and landlords who engage in self-help face both substantial financial liability and potential contempt proceedings. Illinois' anti-retaliation protections under the Retaliatory Eviction Act, 765 ILCS 720, prohibit landlords from terminating a tenancy, increasing rent, or decreasing services in retaliation for a tenant complaining about code violations, complaining to a government agency, or exercising any legal right. If adverse action is taken within a specified period of the tenant's protected activity, there is a presumption of retaliation. Chicago's RLTO adds additional anti-retaliation protections that go beyond the state statute. Retaliation claims in Chicago can result in significant penalties, and the RLTO's specificity about what constitutes retaliatory conduct gives tenants and their attorneys clear grounds for challenging questionable terminations. One critical practical consideration for Illinois landlords. The RLTO's penalty provisions make Chicago one of the most punishing jurisdictions in the country for landlords who violate the rules. Under the RLTO, a landlord who fails to comply with security deposit requirements, fails to provide required disclosures, or otherwise violates the ordinance can face penalties, including the return of the entire security deposit plus interest, a penalty equal to 2 months' rent, and attorney's fees. These penalties apply even if the underlying eviction claim is valid, meaning a landlord can win on the merits but still owe the tenant thousands of dollars for procedural violations. This makes strict RLTO compliance essential for any landlord operating in Chicago. Illinois requires landlords to return the security deposit within 30 days of the tenant vacating, or within 45 days if the landlord provides an itemized statement of deductions. The landlord must provide an itemized list of any damages and costs. In Chicago, the RLTO has even more specific requirements, including the obligation to pay interest on security deposits annually and to provide specific receipts and disclosures at the start of the tenancy. Failure to comply with any of these requirements can trigger the penalty provisions described above. For the complete guide to Illinois lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.